All right, we're gonna wait a few minutes. We on? We're gonna wait for people. About to 7:05. We'll do one more minute and then we're gonna start talking. Because we was here on time. Okay. Good evening, everyone. I am Attorney Cherie Morris. I wanted to speak with you this evening about child custody. So, the other day, I made a post on my Facebook page talking about how fathers who are having children by women who are not their wives do not have automatic rights to their children. Well, that post was shared numerous of times, and I got a lot of questions and a lot of feedback about from people who indicated that they did not know that that was not the case. So I wanted to further explain what I mean when I made that statement. So for those of you who don't know, I practice law in Alabama, Georgia, and Mississippi. Although those states are different, some of the family law laws are similar. But I did want to break down each one and how they differ in each state. So I'm going to begin by talking about the laws and how you obtain paternity in each state. So in Alabama, obviously mothers are the legal guardian and legal parent by birth. That is not always the case when it comes to fathers, especially if you're not married. So there are about 7 ways in Alabama where you can determine or establish your paternity and make your child your legal child. So the first one obviously is marriage. The second one is you can do what's called an acknowledgement of paternity. So that is usually a form that is either given to you at the hospital if you're present at the child's birth, or you and the mother can go down to vital records or vital statistics and get this form. And you both have to fill it out and it has to be notarized. And the form will basically just say that you both agree that you are the biological father and that the child is a legal or legitimate child and has the right to inherit from you, and you have the right to inherit from the child, and all of your rights and responsibilities to that child as with the mother are established at that point. The third way is by a court order. Obviously, you would file a suit for paternity, and you would then establish that you are the biological father and the legal father either by a DNA test or by acknowledgement if the mother does not object to that. The fourth way is by adoption. If you adopt a child, you are obviously going to become that child's legal parent. The fifth way is one of the newer ways. So if you are consenting to assist someone in assisted reproductive, basically IVF. So if you have a contract or some type of partnership with the woman that you want to have a child with, and y'all go and get IVF, that's another way you can establish paternity. The sixth and seventh way are basically what we call common law. And what that means is Basically, you don't necessarily take any legal proceedings to say this is my child, but you have taken in the child, you have raised the child, everyone in the community believes or know that to be your child. You can establish paternity that way. Doesn't necessarily have to be your biological child, but as long as you can show to the court that you have done everything necessary to be this child's parent, you've created a bond, you've taken care of, you've raised them, things like that, then you can establish paternity that way. So once paternity is established, then at that point you have to get custody and visitation. So I don't want anybody for it to be misconstrued. The United States Constitution gives every parent the right to raise their child. So just because you have a child, nobody can say you don't have the right to raise your child, but you have to establish some type of paternity before your legal rights can be recognized. And once your legal rights are recognized, at that point, then you have the right to assert your rights to raise your child, to have custody, to do all the things that mothers typically are assumed by birthright. So what you would do, I like to encourage all of my unwed parents, not just fathers, to go ahead and file a paternity action or to file a custody action while you are on good terms. It keeps down confusion. It makes it easier for everyone, well, the two of you, to agree to a parenting plan, how you're going to establish visitation, how you're going to raise this child and co-parent in the event that you guys do not get married. So that is, I think that's all of the notes I have. That's the process for Alabama. So basically, the bottom line for Alabama, you really just need a declaration saying that you are the legal father, and you need a custodial order from the court saying what your custody plan is, when you're supposed to have your child, what rights that has the court giving you to be able to assert, to do, make decisions, and all those things. Another thing I like to let the parents know, especially the fathers, that they don't know this when you are not married, is that your child does not always have the right to inherit from you if you have not taken certain steps to establish that you are that child's legal father. And what that means is, if you were to pass away and you were to leave behind some fortune or, some type of property, your child would have to fight in order to get something from your estate. Vice versa, if something happens to that mother, the father, the biological father, may not automatically get that child if something was to happen to the mother. That child could go to a grandparent, that child could go to an aunt, an uncle, or a sibling before it will go to the father if the father has not taken steps to establish his legal rights to his child. So also, Alabama has what's called a putative father registry. So what that means is, if you know that you are likely to be the father of a child that's about to be born, and let's just say you and the mom are not on good terms and you don't know what she may or may not do with the child, you can file a form with Department of Human Resources or Human Services that says, I believe I am the father of this particular woman's child. You give your information, you give the woman's information, you give contact information for how they are to reach you. Now, the purpose of filing that is, if the mother decides that she wants to give the child up for adoption at birth, they will have to contact you first before they can adopt that child. So that kind of protects your rights as well if you are looking to be in your child's life, but you're not really sure if you are the father, or if you know you are the father, but you don't know if the mother will actually try and keep the child. So the process in Georgia is way different. So there's only two ways in Georgia where you can establish your legal rights to your child. The first one is marriage, and the second one is legitimation. So legitimation is basically you are filing a suit with the court saying, I believe that I am the father of this woman's child, and I want to be established as the legal father, and In that legitimation petition, you can also petition for custody, you can petition for visitation, and you will also have to establish child support. Now, establishing child support doesn't mean that child support services is going to be involved. It just means that there's a court order for child support that has to be put in place in all Georgia orders involving custody of children. If at the time that you do file the legitimation petition, you and the mom are living together, 9 times out of 10, child support will be at zero or it will be waived because you are taking on the role and responsibilities for paying for everything for the child at that point. So I know a lot of guys don't want to file this because they feel like they're going to be put on child support, but that is not necessarily the case. When you have a court order for child support and it's not initiated by Child Support Services or Department of Human Resources, then the only person who can actually enforce that court order is the mother or the person who ever established it. So don't feel like, you can't file for your rights because you're afraid of child support. And Georgia also has a putative father registry. But the difference with Georgia is that it does not mean that you cannot get rid of the adoption. It just means that you have to have notice. Now, if you filed in the putative father's registry and you haven't taken any other steps to find your child, legitimate your child, get any type of custodial rights to your child, what that means is that they'll just let you know that this child has been placed up for adoption, but you have to take some action if you want to stop the adoption. Other than that, that's all the rights that you have, is just notice of the adoption. Now, in Mississippi, it's a little bit tricky because Mississippi does custody and visitations on a case-by-case basis. They don't have any specific law that outlines what the parent-child relationship is. Now, they do have paternity actions. So the paternity actions are similar to Georgia and Alabama. You have to file something with the court and establish to the judge that you are the biological father. That is typically how fathers' rights are recognized. You can also do an acknowledgement of paternity as well, and that is sometimes done at the hospital, but it's also done with vital records. So you can do the same thing. You fill out the form. It has to be notarized. It has to be filed. Again, after paternity has been established, you still have to establish your custodial rights. You have to go and get your visitation plan. It is not automatic. What happens is when parents get into disputes over custody, the father feels like because he is the biological father, this is my child, that I have just as much rights as the mom. But the mother is automatically assumed to be the custodial parent. And a custodial parent is going to have all of the rights or have superior rights to the non-custodial parent if there is nothing outlined that says you both have joint legal custody of the child. Now, I know I've explained custody in detail on other videos, so feel free to check out my YouTube page and Instagram to go and look at specific details. But a lot of people still don't understand that there is a difference in custody. When somebody asks for custody, in the law, we have 2 separate things for custody. So there's legal custody and there's physical custody. Legal custody means you get to make decisions about your child. Physical custody just means where your child lives for the majority of the year. So when you're asking for custody, you're asking for both the ability to make decisions for your child and where your child is going to live. So 9 times out of 10, all the parents are going to have joint legal custody unless one of them has a capacity where it would be questioned if they were to make decisions. So everybody's going to get legal custody, but again, you have to ask for that. You have to file a petition in court to make sure as a father that you have that established in writing. Physical custody oftentimes goes to whoever is the primary caregiver. It doesn't always have to be mom. As a matter of fact, all states in the United States have gotten rid of the presumption that the mother must be the custodial parent. So that is no longer the case. That is very archaic, and we don't operate in those times anymore. So fathers have equal rights to be the primary custodian. It's just going to determine on what is in the best interest of the child. All states have a best interest of the child standard, and it is determined by a certain number of things. Each state has about 10, I would say anywhere between 10 and 15 things that they look for when making a determination as to where the child should live or who the child should live with. So it's based on the best interest of the child standard. So if you are not in one of the states that I'm in, Alabama, Georgia, or Mississippi, you can always look for wherever you are for what the best interest of the child standard is. And before, I want to make sure that, so in Mississippi, again, they don't have a putative father registry like Georgia and Alabama. So in the event that you do feel like you are going to be in a situation where the mother may try to give the child up for adoption or try to prevent your rights, you can file a paternity suit before that child is born. So you don't have to wait until the child is born. You can get everything started. And what that will do is prevent the mother from giving up her parental rights at the hospital or when the child is born. And it will prevent any other person from trying to institute any type of adoption proceedings, because you have to deal with that one before you can move on. And the bottom line for Mississippi is whoever the child lives with is going to be what we call the de facto custodial parent. And what that means is that we just assume that they're the custodial parent because that's who the child lives with. Again, whenever there is just any type of dispute between parents, it's always best to have something in writing. The best efforts and best tips that I can give you is to do it early when everybody is on good terms. In the beginning, where there's a new baby, everybody's typically happy. Everybody's typically, high and a bliss and everything. So that is really the best time to talk about how we're going to co-parent, how we're going to parent this child in the future. Now, I see I have some questions, so I'm going to answer some questions. Let's see. So the first question says, if a married couple ever gets divorced and only has pets as they never wanted children, however, they consider their pets their children, can you file for child custody in Georgia? So, no, pets are not considered children under the law. So what pets will be is property. So when you are going through a divorce, you will be splitting all of your property, assets, and things like that. So pets will be in that type of category as to property. Courts don't like to get involved with the specifics of those type of things. So it's always best that you guys try and work that out ahead of time, because a lot of judges will give you a whole lot of pushback for making them make that determination. And 9 times out of 10, you're not going to like that determination. Okay, next question says, could child support be used as protective measures? For example, like a prenup protects your assets. Even if the child's father and I are dating or married, could I still put him on child support? So you can still put the father on child support. You cannot put the father on child support if you guys are married and living together, and if you are unmarried and living together. So what will happen is, even if you tried to do it, they'll probably go ahead and institute those proceedings. But all the father has to do is bring a lease or a payment or something down to the Department of Human Services or Child Support Services and show that he is in fact living with the child full time, living with mom full time, and they will not go after him after child support. You cannot come up with an agreement for child support. So the laws in all states say that is really against public policy, and child support and child custody has to be determined at the time there is an issue, and you cannot contract away child custody or child support. So those are absolutely frowned upon. So you couldn't do that. You couldn't equate that with the prenup situation. Okay, next question. How is it considered joint legal when one parent can be deemed the tiebreaker in all? Wouldn't it make more sense to split the 4 areas of legal custody? So typically, when I do my parenting plans and we have to establish who's going to be the tiebreaker, I prefer for the parents to have two and two, because it does get into a situation where some person may feel like, well, I'm the tiebreaker, so I'm just going to make the decision. And that's not what the law wants you to do. If it is a tiebreaker, it's the parenting plans usually state that they will talk to one another. They will try to come together and make a decision. And then after they've talked and conversed and discussed it, if they still cannot come up with an agreement or a consensus, then the tiebreaker gets to make that decision. For example, when we're talking about extracurricular activities, if one parent has the tie-breaking vote in extracurricular activities, that person will end up having to pay for all of the extracurricular activities. They will have to make sure that that child is at all of the practices, all of the games, and if at any point in time any of the practices or games cut into the other parent's time and that other parent doesn't want the child to go, they won't have to go. So you have to be careful with that tie-breaking vote, because it could backfire on you. It could make it where you've spent this money for this child to do something, but when the child is with the other parent, because they did not agree to it, they're not going to do it. So then you're back in court filing a contempt action because now you've wasted money and the child can no longer participate. So you want to be very careful with that. But just to answer your question, other than the courts really persuade the parents to try and co-parent, it's really it doesn't make any sense at all, honestly. So that's why I like to give them two and two, so it makes everybody bend. It makes everybody compromise. Okay, so next question. And if I answered your question and you still have some more questions, feel free to ask a follow-up question. I'm perfectly fine with that. Okay, next question says, what about the parents that aren't letting their father see their child during the crisis, even though they have a court order for visitation? So, Mississippi and Alabama have not made any type of statements as to how visitation should or should not go when it comes to this situation. In Georgia, certain courts have, and the recommendation from the courts is that visitation should resume as scheduled according to the child's school schedule. And that's specifically for here in Georgia. So, for example, if the children were alternating on a week-to-week basis, the courts will recommend that you still do that. If you're doing every other weekend or spring break, that you still follow your custodial plan even during the crisis. However, you have to make sure that you be smart about that, because if the custodial parent is a essential worker, for example, and they have to be gone all the time, the custodial parent should allow the non-custodial parent to take up that time or take up that slack, because it is safer for the child and the custodial parent to do so. Also, you also have to think about the amenities that that child might need. So some people may not have the same access to internet. They may not have the same resources. Some people may not even have enough food to care for or to keep that child during this extended period of time. So in that regard, you should allow for the other parent to come in and step in. And also, I think that it's very helpful that you do allow some additional time with the non-custodial parent, because the child is in the house all day, every day, and it will allow them to break up that monotony if they can go do that somewhere else. And it'll give the custodial parent a break, and it'll allow both the non-custodial parent and the child to have some additional bonding time. So I would just encourage the parents to follow the order as written, unless it is not safe for you or for the child or for the other parent. And also, the other parent, if you are going to get the child, that you should also use the same measures of quarantining, stay home. You can exchange the child in public or whatever, but make sure that the child goes from one house to the other house and has limited contact. So you still want to keep the same rules regarding quarantine. Okay, next question. How can one say they have joint custody when one parent is deemed the tiebreaker in all areas. How is that considered joint? So again, that question is basically joint legal custody means that you both have the ability to make the decisions. Tiebreaker means we have had an exhaustive conversation, discussion about what we're going to do with this child, and I still, whoever the tiebreaker is, if it's mom or dad, I still think it's in this child's best interest that we do it this way, or that we put them in this particular activity. So it's still joint. It means that neither one of you can unilaterally make a decision. Like, mom can't say, well, I want the child to play basketball, so I'm going to go put the child in basketball, and never consult with dad about basketball, never consult with dad about the schedule or what dad has available or what dad has planned for the child. So you can't unilaterally make a decision. You both have to come to a joint decision, and then once you guys have tried to discuss it, then at that point, the tiebreaker can make the decision and say, well, I still think it's in the best interest. If the other parent who is not the tiebreaker feels like the parent who is the tiebreaker is making a decision that is not in the child's best interest, they can always go back to the court and file a contempt motion or file a modification or file some type of motion that lets the court know, hey, this parent is not doing what they're supposed to do. They're making bad decisions for our child, and it's putting the child at risk, and I think we need to revisit this. You can always do that. So custody plans are not set in stone. You can always modify them as long as there is a change in circumstance, or you can modify them by agreement. You don't necessarily have to follow the plan as written as long as the both of you agree. The next question says, if both parents move out of the state of Mississippi, does the new state the child live in have jurisdiction if the parent wants to file a modification? So I get that question all the time, and that goes for every state. If you have a court order in one state and everybody has moved away from that state and moved somewhere else, what you have to do is file what's called a domestication of a foreign order. So what that means is, you're asking, for example, let's say you have a court order in Mississippi and everybody has now moved to Georgia. What you would do is take your Mississippi court order and you would go to the Georgia court in the county that you live in, and you would file it, and you're asking Georgia to now accept the jurisdiction over our child custody provisions so that I can make modifications according to Georgia law, because that's where everybody lives. So that's what you would do to make modifications when you move out of the state and nobody still lives there. Now, if one parent still remains in the other state, or if the child still lives in the other state and then the other parent has moved out, then you have a conflict between the jurisdictions. So 9 times out of 10, the original court will retain the jurisdiction, because that's what it says. That's what all the law says, that the original court has that jurisdiction as long as someone still lives in that state that they can exercise jurisdiction over. Okay. The next question says, what are some of the issues that determine legal custody? So honestly, legal custody is usually not an issue unless, like I said, one of the parents is unfit. So if you have a habit of making bad decisions when it comes to, putting your child in certain situations that may be dangerous for them, letting them do certain things that, could be that could harm them physically, or could damage them emotionally, or cause them, to have some other type of issues, then that's the only time where legal custody will be questioned. But 9 times out of 10, if everybody is normal, sane, and, living life, everybody's going to be able to get joint legal custody. Okay, and the next question says, if a parent is moving out of the state, what are the rights of the other parent to stop them? Are they allowed to just move? So if you are not the custodial parent, 9 times out of 10, you can move without question. Nobody's going to really bother you. It's not going to matter. However, if you are the custodial parent and you're trying to move away, then that obviously becomes an issue. So what you have to do is file a modification of custody in the court, and you should do it before you get ready to move. So at the time that you know you're likely to move is when you should file the petition for modification. And what will happen is either the court will say you can't take the child, you lose the custodial parent designation, they have to stay here with the other parent, or you will have to modify the custodial plan or the parenting plan that you do have to make sure that that non-custodial parent still has all the time that they would normally get when you guys live together. So the best thing you can do is file a modification of custody. You cannot move out of state with your child unless you have a court order that takes into account for your move. Otherwise, you're going to be fighting an uphill battle, and you're going to be flying back to wherever you moved from to go to court to get it done, and you may not even be able to take your child with you. So you always want to be proactive in that regard. Okay, the other question, what if the child moves out of state with the other parent, not the custodial parent in the order? So same thing, you can get that child back, you can bring that child back, but you have to file something in court that says that they moved out of state without my permission, and I don't agree with them moving, so I want the child to come back. I've had a good number of cases where literally the judge said, you need to have that child back here tomorrow, or you're going to sit in jail every day until that child gets back here. So I've had situations where that has happened, honestly, in all 3 states. So you don't ever want to move out of the state and take your child with you if you don't have permission from the other parent, or if you don't have anything for a court order. Also, I just want to let everybody be known that, again, I stated earlier, there is no preference to mothers. The law does not allow for a preference for mothers. Both moms and dad have equal rights to custody. However, I will say a caveat, it does not mean that your judge, your specific judge, may not be biased toward a mother or toward a father. I have practiced in a lot of counties where I've seen it go either way, where a certain judge leans more toward mothers, and then there's another judge that may lean more toward fathers. So it doesn't mean that your individual case may not have bias, but the law in general says every parent is equal. Okay, next one says, how long would a parent have to wait to modify child support or child custody? So for both of those, you can modify anytime if there is a change in circumstances, if there is a material change in circumstances. And what that means is something has to happen that makes our current plan no longer feasible. So in child support situations, if you are the paying parent, if you lose your job, you need to automatically file for a modification of custody. If you are the custodial parent and receiving child support, if you know that the other parent has gotten a raise or some type of increase, you can file at that time to ask for an increase in child support. You can file for an increase in child support anytime that the paying parent receives an increase in pay or income, or if your child has increased expenses. For example, if your child has special needs or something like that, or they need an additional tutor or anything like that where it's a required expense, you can always file to modify child support to increase it to cover the additional expenses. Okay, next question. What if the father is currently pursuing custody and the child resides with him, but the mother still receives child support, Medicaid, food stamps, etc. in her household? What can be done? So honestly, I would say that is a slippery slope, because if the mother is receiving any type of government aid and the child is not living with her, then the government will make you pay everything back that they have given you. So you don't ever want to do that. If you were receiving it because the child lived with you and you guys voluntarily changed custody, you want to go and let your caseworker know that the child is no longer living with you, and you need to go ahead and modify whatever type of assistance that you have. If you have additional children or additional dependents, then they'll reduce it to remove that one child. or if that was the only one you have, you need to be able to go ahead and remove that, because they will make you pay back that information, everything that they've given you. So you don't want to do that. Okay, so next question says, what's the best advice you can give fathers who are skeptical about hiring an attorney to represent them? So the best advice I can give to fathers is, one, don't ever go into court alone if the other parent has a lawyer. You never want to do that, because you're not going to win. It doesn't matter if the law is on your side or not. I have literally had to have clients, especially fathers, hire an attorney. Even if it wasn't me, I tell them, hire an attorney, where the mother was represented by an attorney and the mother was horrible. Still doesn't matter, because you're not going to be listened to. And it's an unfortunate reality that I have to let people know. If both of you are unrepresented, that's perfectly fine. But if one of you is represented, 9 times out of 10, the person who's not represented by an attorney will get the short end of the stick. That's just the way the cookie crumbles. It's an unfortunate situation. I like to tell everybody the justice system isn't fair. So don't believe that. Don't go in to court thinking that, I have a good case, everything's right, all the facts line up, I should get what I want. It might be true, but you're probably not going to get what you want. That's just the harsh reality. And a lot of people don't want to be upfront about that and tell you that, but I like to let people know ahead of time, it's not going to be an easy thing. Anytime that you're asking, you're inviting somebody else to get in your business, basically. You're inviting somebody else to tell you what to do with your life. So as much as the judges get paid to sit and listen all day, they may enjoy it, they may not enjoy it. They don't want to be in your business no more than you want them in your business. So just keep that in mind when you're going through this process. Sometimes it's a necessary evil, so you have to do so. Always look for an attorney that is going to represent you and what it is that you want to pursue. I disagree with clients all the time, but that doesn't mean that I'm going to do what I think they should do. I'm going to tell them what I think they should do, but at the end of the day, this is their life and their case, and I'm hired to do what it is that they want me to do. I will let them know up front, whether or not I think it's going to be a good outcome or bad income, whether it's going to be a risk or a juggle, whatever it is, I'll let them know. And then if they still want to pursue that, that's my job, is to pursue it on their behalf. So always look for an attorney who's going to do and pursue what it is that you hired them to do. Also, shop around, make sure that you talk to enough attorneys that you feel comfortable with. Make sure you're paying a good rate, a rate that you can afford. Every attorney charges something different. We are allowed to charge what we want to charge. So definitely shop around and make sure you get a rate that you can afford. Okay, so next question says, what if the custodial parent did agree to allow the child to move out of the state with the other parent, but it wasn't taken back? So if you allowed the other child to move out of the state with the non-custodial parent, what you need to do, what my suggestion would be, is for the both of you to file a petition for a change of custody and just go ahead and put it in writing, whatever it is that you want to do, and just submit it to the judge. So in that situation, it's basically an order by agreement or a settlement agreement. So you don't necessarily have to go and fight and all that other stuff. You just file a petition saying, hey, judge, we've come up with a modification of our original order. We just need you to sign off on it to make it legal. Judges will do that all the time. It's going to be cheaper than fighting in court. It's going to be quicker than fighting in court as well, because you both agree. So in that situation, I would just advise to go ahead and change the parenting plan so that it reflects what your current situation is. But if Medicaid or whomever didn't take anything back, don't rock the boat. If they didn't do it, that's on them. That's for them to pursue. But honestly, to protect you, you should, make sure that you take everything off of you. Take the responsibility off of you and let them know that I've done what I was supposed to do to let you guys know that this child is no longer living with me. But if they don't pursue it, they don't pursue it, so that's just what you're stuck with, and it's a windfall for you. But don't take advantage of it, because again, they can come back after you. Okay, so next question says, in the COVID crisis, are parents allowed to stop or pause their legal agreements dealing with visitation? So, nope. I talked about that a little bit earlier. Nope, the parents are technically not allowed to do so. You must follow it the way it's written while we're still in this crisis. Obviously, you should be more amendable to making concessions and, compromising so that your child still is enjoying both parents during this time, but obviously remaining safe, being safe. You have to stay quarantined, just like the child would stay quarantined at mom's house. The child needs to stay quarantined at dad's house. So you still want to do that. If you guys find yourselves in a disagreement about the situation, you need to document everything, because you are going to have to file a contempt of court, and you won't be able to file it until the courts open back up. But you need to have everything documented, because we don't know how the judges are going to respond to these contempts for this crisis. But you also don't want to go back to court and let it be known, or not let it be known that you missed out on this time. So I don't know how they're going to award contempt punishments. They may say, all right, well, we're just going to let it pass, and everybody move on with their life. Some of them may say, no, you should have done what you were supposed to do, so we're going to punish you this way. So honestly, I would just say, do what you feel is the best thing for the child in the situation. Don't be selfish. Think about your child, because your child, just like your child wants to be with mom, your child wants to be with dad as well. Child may have siblings with mom, just like they may have siblings with dad. So you don't want to cut them off completely from what they've been doing, because it's a hard situation for us as adults. So it's going to be an even harder situation for the children, because they're confused. They don't know what's going on. And taking away that normalcy that they had as well may also cause more confusion. So you just want to be mindful of your child's emotional state, mental state, physical state, and, do what is best for the child. Okay, so this question says, for the ones that are recently divorced, how long should you wait to get the courts involved or MDHS involved? So I'm assuming you're talking about child support. So if you are recently divorced and you don't have a child support order in your divorce decree, then you honestly need to modify your divorce decree immediately, because you should have, in your divorce decree, it should have dealt with custody and child support at the same time. So you don't have to wait. You need to go back and just revise that. If you want to get Department of Human Services involved, obviously you can do that at any point in time, as long as you two are not living together and they're not paying any child support. You can get them involved at any point in time. But best advice would be to go back and modify your divorce decree, because it should have been done in your divorce. Okay, so if you are currently getting divorced, how long should you wait to get them for court? Okay, so if you are going through the divorce process now, you need to ask for temporary child support. So you can always, it doesn't matter what stage of the divorce that you're in. If you're in the beginning, you need to ask for a temporary court hearing that's relatively quick, within 30 days, so that you guys can establish some temporary child support. If you're near the end, you can still do the same thing, but wherever you are in the divorce case, you need to get a temporary order of child support so that you can be receiving child support through the divorce process. Okay. So the last question, it's going to be the last question before we go. It says, has an actual court put out a statement regarding the crisis? If so, where can you find the letter? So I have not received any statements from any courts in Mississippi or Alabama that makes a statement. I have received in the metro area for Atlanta, it is Cobb County. So if you go to the Cobb County Superior Court website, they will have their statement. And then there was one, I want to say in Paulding, or it was one of the counties outside of the metro area. So those are the only two counties that I've received an actual statement from the court regarding parenting plans and how you should move forward during the crisis. But always, what you can do, always check, if you're in Georgia, check the Superior Court of the county that you live in for any updates regarding the COVID crisis. If you are in Mississippi, check the Chancery Court in the county that you live in. If you're in the Alabama, check the Circuit or the District Court, because it could come from either one. It could also come from the Juvenile Court. So check there in the county that you live in. And they should have, if they made a statement, it will be on their website. So that's where you could go to look for that. If you have any questions for me outside of this live, I did see someone ask to save this live, so I'm going to save it so that everybody can go back and review it. So if you have any other questions and that I did not answer, or if you want further information, I'm always available. I do give free telephone consultations, so you can feel free to give my office a call. Also, if you want to make an in-person consultation when we go back to work, then you can also do that. Again, I want to thank everyone for joining my live, and thank you for joining me, and your questions were great, so I definitely appreciate that. If you want to reach me, I can be reached on all social media platforms at Cherie Morris Law. That's Facebook, Instagram, and Twitter. If you want to give me a call in the Atlanta area, my number is 678-903-3838. If you're calling from Mississippi or Alabama, the number is 601-460-1044. Is that my number? No, what's my number? Sorry, guys. That's not the number for me. It's 601-460. You don't have the number, Dexter? If you turn around, it should be a business. It should be a business card behind you. 601 460 1779. So that's the number for Mississippi and Alabama. I can also be reached via email at my first name, Cherie, at CherieMorrisLaw.com. Again, thank you everybody for coming. Stay safe out here. Wash your hands. Lysol. Sanitize. All right, we're done. That's fun.